Hi everyone, it's Amy here from the blog I Think Therefore I Teach. Welcome to your next Criminology video. This one is for Unit 3 and it's 2.4. So let me make myself smaller. There we go. Okay, so Unit 3, Topic 2.4. This is assess key influences affecting the outcomes of criminal cases. It's an assess, which means you need to evaluate. You need to look at the strengths and weaknesses, what's good and bad, etc. So what you need to know then is 7 different areas. You need to talk about each of these 7 and assess them. So you need to look at the evidence, witnesses, experts, judiciary, media, politics, barristers and the legal teams. You need to be able to show an understanding of the many factors that can influence the outcome of a trial and be able to assess their impact. So that is the language you have to use. You have to talk about evidence and how it's affected the outcome of a trial and assess their impact. So assess each evidence's impact and how it has affected the outcome of a trial. So using examples from a range of case studies we've studied, I got my students to link each of the key influences and all the ways it impacted the outcome of a trial. So for example, how did the media impact the outcome of the Hillsborough trial, or the witnesses in the Sally Clark case, and how they affected the outcome. So I got them to think of as many case studies as they could. The evidence is always a good one for the Amanda Knox Meredith Kirch case. Witnesses is always a good one in the Sally Clark, so as experts. Witnesses also, you've got the Damilola. Media is good for people like Barry George. It's also good for, what's he called? Christopher Jeffries, that's another good case for the media. The Hillsborough case is good for the media. So we've looked at many cases and looked at things like, so again, how the experts affected the jury decisions in the Sally Clark case. So a lot of it's interlinked as well, but once more, trying to link your case studies in as early as you can to a topic is very important. Knowing your case studies is absolutely key. So, evidence, the background. A juror's oath. The jury swear by Almighty God that I will faithfully try the defendant, so this is the jurors, defendant, and give a true verdict according to the evidence. So the evidence should be the primary, most significant influence on the verdict. This is very interesting when it comes to the Jeremy Bamber case. I haven't discussed the Jeremy Bamber case because it comes up in a couple of topics' time, so my students at this point hadn't talked about the Jeremy Bamber case, but again, they can then backstate it. So Jeremy Bamber is a really good one for how they use the evidence and how actually the evidence doesn't necessarily point to Jeremy Bamber as the killer. If it was just purely on the evidence, that's then maybe questionable how the jury made their decision. It can be physical or a testimony. CPS decide if there's sufficient strong evidence, and you already know about the CPS now, Crown Prosecution Service. And it's all to do with the burden of proof. The burden of proof is on the prosecution. Burden of proof means that they have to prove their claims. Their burden to prove their claims is on them. So if they're saying that the defendant is guilty or not guilty, and so they're so that's that, you know, that's the prosecution line. They have to then back it up. All the defendant has to do, all the defence has to do, is then argue why the evidence does or does not work. That's where it fell down in the Amanda Knox case, because in the Amanda Knox case, all they had to do was say why what the prosecution was proposing did not work. They didn't have to say they didn't have to give any other reasons. They didn't have to give any other evidence. They don't have to have the burden of proof on the defence. It is down to the prosecution. So, for example, when the prosecution raised the bra strap, all the defence had to say was it was found 47 days later or whenever it was, and therefore is inadmissible in court. So all they have to do is just basically attack everything that's mentioned by the prosecution. The evidence must be beyond reasonable doubt. The jurors must interpret and decide what weight to give the evidence, and any doubt, and a person should be found not guilty. So if there's any doubt at all, not guilty is the verdict. So this is now, so that's the background of what evidence is. For this controlled assessment markings, you need to then assess it. You need to assess how valid, reliable it is, and how much impact it has on the outcome of the trial. So can you think of any case study where the evidence had a significant effect on the outcome of the trial? So as I said, for example, the Amanda Knox case. What are the pros and cons? So I got my students to discuss the pros and cons, and then I shared a few. Can be empirical proof of aspects of the case, DNA or fingerprints. So DNA and fingerprints are very, very hard to disprove. They're either your fingerprints or not. They're either your DNA or not. So this is empirical, actual, physical evidence. Can be seen, it can be assessed, it can be agreed upon by different people. So it's again objective. Scientifically tested and analysed. However, it can become contaminated or deteriorate. So contaminated, like in the Adam Scott case, where his DNA was taken from another, put in a petri dish, mixed with someone else's, and therefore he was found guilty of rape when actually he was not even in the area. It can deteriorate. So again, the 47 days later, or whenever it was for the bra strap. It could be handled or processed wrongly, so human error. So again, that's the Adam Scott case, where it was the human error that handled it incorrectly. Things have been processed wrong as well. Things haven't been found or picked up or mislabeled. So the Stephen Lawrence case, they found that there was something far nearer to the crime scene, but it was mislabeled, so it seemed a lot further away, so they just kind of dismissed it and thought it's not of any relevance, but actually it was a lot closer to the body. I think it was a bag strap or something like that. So this was only found very recently. The bag strap was found and it had been mislabeled, so it had been dismissed at the time, but now it's been looked at for DNA, and they found a female's DNA on it, and she could have been a key eyewitness that was never brought forward because the bag strap was ignored because it had been labelled and processed wrong. And it can be misinterpreted as well. Witnesses then, the background. It can be called by both sides, prosecutor and defence. Usually expected to appear in person. Again, you already know the exceptions. We've covered these in previous videos. They could be vulnerable and therefore have special arrangements. And again, these are areas that we've discussed before. The examination in chief, cross-examination and then re-examination. So the prosecution present their examination. The defence then counter that and raise their problems with it, and then so with the witness they can then re-examine the witness. So this witness is under an awful amount of stress. This witness really is grilled and put on the stand. So they will first of all answer questions from the prosecution, they will then answer questions from the defence, and then they could have further questioning. So it really is a very intense for the witness. It's up to the jury to decide how to interpret what they say and what weight to give them. So again, I've got them to think of the advantage of using witnesses. So eyewitnesses, obviously they were there. They saw what happened. Especially if there's only the dead body as well and there's no other witnesses that were around, because obviously in the Stephen Lawrence case with his friend Dwayne was actually there. He witnessed everything, but his statements weren't taken seriously. And again, that was something that you can talk about in the disadvantages. But you know, these witnesses, are there. They see potentially what happens. And can you think of a case study where the use of witness was detrimental? So again, the case studies where witnesses were detrimental, expert witnesses like in the Sally Clark case, witnesses in how they treated Dwayne, the witness like Bromley in the Damiloli case. There's many witnesses that we've come across that can often be detrimental as well. So then I got my students to rank, order and hand out the issues according to how serious they are, from 1 to least and 5 to most. So these were just general things like the person was there on the time of the incident, down to things like it's very, very hard for the witness to remember things accurately. When you are under great amounts of stress, you might, you might not recall things, or you might. There was a case study we looked at in a previous video I can't remember who came up with the case to the research study, but basically if there's a weapon, you focus so much on the weapon, you don't actually see the person, or your brain doesn't process the person as much as it does the weapon, because obviously it's the fight or flight, your evolution. You're watching the thing that can hurt you rather than the person wielding the knife, for example. And then I got them to draw the conclusions. How can witnesses impact the outcome of a trial? Experts, a type of witness. They could be called by both prosecution and defence. Unlike ordinary witnesses, they're allowed to express their professional opinion on a case because of their expertise. So these are people that were there. These are people that just pass their professional opinion about a case. They can have a very important influence on a jury because they have expertise and a jury is not expected to. So don't forget, the jury can be anybody. They can be of 18 plus, 18 to 69. The jury are trained. They might not have no educational background. They will listen to everything that's presented to them. And when you've got a doctor or somebody of some standing or expertise in front of you, you're probably going to really put a lot of weight onto what it is that they say. It's up to the jury again to decide what weight to place on their testimony. Can you think of 2 case studies where expert witnesses affected the outcome of a trial? So the first one might be, for example, the Sally Clark case. Another case might be Hillsborough. In Hillsborough, they got doctors and things to talk about, and they gave times and said at this time, I think it was like 3:24 or something, everybody was dead. Yet they know that actually somebody was brought out of the crowd at I think 3:36 or something like that. Again, check your timings because I don't know how accurate they are. It's a while since I've gone over them. But that was still alive, and the witnesses around it said this person was still alive, but the ambulance couldn't get through. The ambulances didn't think anybody was still alive, etc. But that witness came forward and said everybody was dead by this time. And so that again was taken really seriously. But I'm sure you can think of other expert witnesses as well. They can be very helpful. They can clarify issues, highly influential, but the jurors may not be able to check their claims. They can also be far too complicated or specialist to understand. At the end of the day, if you've got a paediatrician, or a pathologist, a highly trained expert in front of you telling you things, you might not have a clue what they're talking about. That's how Sir Roy Meadows got away with the statistics, because the statistics were so complicated as to how he'd come to it. People just accepted 1 in 73 million. They didn't question it. They didn't look into how we actually came to that statistic. And then obviously it was other experts later that came out to say that statistic does not stand. Some experts may be better at explaining things than others. And again, I got my class to discuss why this is an issue. And at the end of the day, if you understand one expert more than another expert, you're going to go with the one that you understand more. Think of it like teaching. This is what I said to my students. Think of it like teaching. You're going to lean more towards the teacher and the subject you understand, and away from the subject and the teacher that you don't understand as much. So this is exactly human nature. You're going to lean towards somebody. Also, the way that the experts carry themselves can be really impact on the jury. So if somebody is very clear speaking, if somebody is very articulate, very demanding of the presence, the jury will really believe what it is they're saying. If a person's on the stand, whether it's an expert or just a witness, and they're mumbling and they're quiet and they're and they're umming and ahhing and the jury's not necessarily going to lean towards what they say, even if what they say is really accurate. Sometimes experts contradict each other as well, and again, who should the jury believe? The experts from the prosecution might disagree from the experts from the defence. That's exactly what happened with a lot of the DNA that was found in the Amanda Knox Meredith Kircher. The prosecution said, no, this blood is clearly Meredith Kircher's. However small it is, it's still there and it's still hers. The defence went, no, far too small, you cannot draw that conclusion. Who do the jury then go with? And they can sometimes get things wrong. The judiciary then, so the judge can be extremely important influence on the outcome of a trial. They are a legal expert, so they present useful knowledge. They summarise the evidence and guide the jury as the decision required of them. So in my teaching, in my classes, the students will often say comments, and I will summarise them for the class. But by summarising, you change the language, you change the wording, you change the emphasis. I emphasise, just by my intonation of my voice, the parts that are good, the parts that work from the answers. So a judge, even without knowing it, in his summary might affect the jury and how and what they take on and what they believe. How the judge does this could influence the jury if they favour one side over the other. Judges are allowed to advise the jury to come to a particular verdict. Now, that's really serious. That's a really serious one. Again, if you were a jury, you're a 19-year-old, obviously you can't be a student because you don't have to do the jury if you're a student, but so you're a 19-year-old straight out of college, worked down at the local shop, I've lived in a tiny little village, I've no life experience, and you've got this judge, this person up there that has years of experience, that's paid thousands and thousands of pounds every year. You're going to listen to what that judge tells you. They're going to have a huge impact on how you lean as far as the evidence. If they go against this, so if the jury go against the judge, it's a perversion or a perverse decision. Though this is allowed, the jury must do what is just and fair. Again, it's not my place to say my views on these things because this is just as it is, but to have the connotations that if a jury then go against a judge is a perverse decision, maybe it's just the word perverse, but the word perverse is quite a strong word. If as a jury you think, it's a perverse decision, we shouldn't really be going against the judge, do they really? That'll have to be a fairly confident jury, a fairly confident 12 people to say, no, this is what we think and we're staying by it, to go against what the judge is indicating. That's quite a hard thing to do. Judges can also influence by controlling the questioning of the barristers. They can stop questions, they can allow questions. They can dismiss cases and order retrials, so they can just close cases down and then order retrials later. The CGA also allows them to order juryless trials if deemed a risk of tampering, intimidation or too complicated. So they can actually order for there not to be a jury. They pass the sentence. And so what I got my students to do is, again, rank order these from most influence to least influence. And again, we discussed them. So we discussed which ones of these, because again, don't forget, it's about how they impact the outcome of a trial. So which ones of these do you think impacts the outcome of a trial the most? So the judge was the one that got rid of Bromley in the Damilola case. The judge was the one that, oversaw things like the Hillsborough and what was allowed and what wasn't allowed. The judge has a serious impact on the outcomes of trials. And again, so it's important to recognise that. So then I got my students to do a bit of research. They used a page in their booklets, but you can find this information online as well to help you. So what typical educational background is there of judges? How does this compare with just general population? What impact might this have? What is the gender division? What impact might this also have on certain trials? And then again, I got them to read the articles from April 2019 on the Mr. Justice Hayden and what opinion of his judgment and the response that was made by Women's Aid. So what you will find is that obviously judges have an extremely high educational background. They are from very prestigious universities quite often. They're often more men, so they are more men quite often. But again, you need the statistics, you need things to back this up, but don't forget we're doing it within the UK. The media. List all the examples and case studies that you can remember where media influenced the trial outcomes. You've got Jeremy Bamber, you've got Christopher Jeffries, you've got Barry George, you've got Hillsborough, you've got Amanda Knox. The media gets into all of these. Every case, Stephen Lawrence, Damilola Taylor, the media has an immense impact on trials and trial outcomes. You've got things like moral panics. So moral panics, like we did this right back in the first year, I think 1.3 or 1.4, when we looked at moral panics in the media and things like the mods and rockers, how there wasn't really an issue, but the way the media spun it made an issue. The London riots, some people got really severe sentences where normally there's things like looting and stuff, when they wouldn't normally, because they wanted to make a message and send it clear through the media that this is not something that's acceptable. acceptable. Again, the media spun it. You've got the John Venables and Robert Thompson, and how the media looked into that case, how they were portrayed, etc. Media can inform the public and raise awareness. So it's a good thing. Media is a good thing. It's not a bad thing most of the time, because it does give us the information. It keeps us in the loop of what's happening. But the coverage can be sensationalist and biased. It can be difficult to find objective jurors. So what that means is you cannot stop the jury from looking at social media. You cannot stop the jury from reading the newspapers, and that will affect their views. So when you've got Christopher Jeffries, for example, the peculiar and bizarre peeping Tom, as the media talked about him, and then this young woman that's murdered in a flat that he had the key for, and then the papers completely spun it into really emphasising the peculiarities of him. It's very hard for a jury to ignore that and to make an unbiased decision. And obviously they want to sensationalise things because they want to sell newspapers. So the coverage can be very, very biased. For that one, again, I'd find specific examples. All you have to do is Google things like Christopher Jeffries newspapers. Get headlines. In the Sun, this date calls in this. Absolutely spot on. 1 in 5 of jurors admit to finding it hard to ignore material they've read in the media about their case. Social media is an increasing problem in interfering in a fair trial. And so I got my students to research the case of Angela Wrightson and then watch the documentary on about the influence of the media in the case of Christopher Jeffries. So again, we looked at how the media influenced Christopher Jeffries' case. Politics. Laws are made in 2 main ways in England and Wales: through setting precedents, common law, statute law, which is acts of parliament, and then so politics can have a real impact on the law generally, though decisions which make some things legal or illegal. So the law really does impact what is seen as legal and illegal. Statute law comes about by the government proposing a new law or change. Parliament discuss this, they then vote on amendments, and the final vote on whether it should become law. So proposing a new law, for example, the Sarah's Law. A change of law could be the double jeopardy. So these again are examples of things we've done previously, but you can really use them here. 3 main ways the laws can be changed: by just getting rid of the law completely, like the laws we had on homosexuality, for example. New laws, or changing sentences. So if someone's found guilty, they're given a longer or shorter sentence. And again, I got my students to think of any examples. And they read some examples in the handout. And again, they thought of the pros and cons of politics being influential on law and sentences. So they thought about how politics and these things can really influence the law and the sentences given. So another really good case is obviously the James Bulger case, because John Venables and Robert Thompson were 10 years old, I think, when they did it. But they waited until they were 11 so they could be tried as, and they established very early on, you knew what you were doing, you know the difference between right and wrong, you know why lying is good or bad, etc. So they were very, very careful to establish that these boys knew exactly what they were doing and wanted them to be sentenced as adolescents, not as children, because again of the influence on the outcome. Final, barristers and the legal teams, they can be highly influential on a jury, therefore profound influence on the outcome. They have an adversarial legal system. Each side puts its case before the jury, therefore the more skilled and persuasive barristers have more impact. If you need a barrister, if you have more money, you get a better barrister. Amanda Knox was a rich, white, female American and was able to provide and use a legal team that was extremely persuasive. And I do mention her, obviously, wealth, because she was able to do it, but I also do mention her gender and her colour, because when we look at these cases, people are treated differently because of the colour of their skin, as we know by Dwayne and Stephen Lawrence. And when you look at the Amanda Knox case, the person they found guilty was the immigrant living on the top floor. I cannot remember his name, but he's still in prison now. He got 25 years. Why? Because foreign, he was from a different country, he had no money, so he could not afford persuasive barristers, and so he was immediately deemed guilty. Yes, he was the one that laid the blanket over her, and his DNA was all over the blanket and the body and things, but he was found guilty before he was found innocent. Also, the issue of juror infatuation could lead to bias. If you've got somebody, you know, a prosecutor or a defence that's, you know, very captivating, charismatic, you could become infatuated by them. You could listen to everything they say and agree with everything they say. It's good that we have experts to represent ordinary people, so it's good that we have them, but bias might be a problem if one side is more skilled than the other. Is it right that the verdict might be affected by the skill of the barrister on your side or another? At the end of the day, you have to have a blooming good prosecution, because all the defence has to do is say why the prosecution's evidence does not work. If you have a prosecutor that isn't confident, isn't astute, isn't on the ball, can't articulate themselves convincingly, yet you have a defence that can just confidently and charismatically take that evidence apart, it again really goes down to the personality, which is why on the first slide of this, the evidence, you know, everything holds on the evidence. The evidence cannot be disputed. The evidence is as it stands, whether it's by a passionate defence or prosecutor or not. That evidence does not change. So that's why jurors should really put the most on that, not their likings for the prosecutor or the defence team. There could be social injustice if the wealthy are able to afford better legal teams, which they are. All right, I hope you found that one useful. Do not forget, you have to look at the strengths of witnesses. You have to be explicit in the language that you use. So make sure you say a strength of this is, a weakness of this is. This makes it credible. This makes it valid. This is an advantage. This is a disadvantage. This is a pro. This is a con, etc., etc. You have to be explicit in the language that you use when talking about these. You have to be specific in the parts of the case studies you use as far as your links. You also need to make sure you aren't just talking about the evidence, you're talking about the impact they have on the outcome of a trial. So it's not just whether the DNA should or should not have been used in the Amanda Knox case, it's how the two different perspectives from the prosecution and the defence, how that then impacted the outcome of the trial. So that's the key bits, and you have to use that language in your controlled assessment. Right, thank you very much for watching. I hope you found this video useful. Don't forget to subscribe, and then you never miss out on the next instalment. If you have any questions, please pop them below. Otherwise, thanks very much for watching, everyone. Bye for now.